Okay, let's continue. Uh, let's talk about gift and situations where you would use it. The one thing about gift is is that when you receive a property in gift or when you're gifting a immovable property as a gift, it has to be formally accepted in writing. That is mandatory. So, because what happens is many times you may have a property which is more of a liability rather than an asset, and as per the law, a gift has to be formally accepted in writing. That yes, I am accepting this gift. Secondly, you have to pay stamp duty as per the sale. So, in case of Gujarat, the stamp duty for uh, sale and all other kinds of transfer is 4.9%. So that is usually paid by the donor. Donor is the person who is giving the gift, whereas donee may be responsible for getting the registration. Okay, which is 1%. Okay, 1% registration charges, and upon registration, a gift cannot be regifted. So that is an important part of gift. What are the situations in which a person may give a property as a gift? Well, there could be income tax implications. There could be a situation where the person who is receiving a gift may may not have money to pay for that property, or may have just cash to pay, and may not have a single rupee in the check amount to pay. And so, in those situations, the person may consider giving it as a gift. But again, just like a vendor or a vendee, in this case, you have a donor and a donee, the two parties which is in this transaction as a gift. Let's look at exchange. Uh, what is an exchange? This is the final kind of a transfer I will talk about. And before I talk about exchange, it is important to mention that whenever a real estate property or an immovable property uh, is transferred from party A to B. So let's say that A owns this property, and let's say the A is selling it to B. Okay, so B is receiving this property. What B gives back in return to A, okay, is called consideration. Okay, as per the law. And consideration is a term that is very popularly used and mentioned in the Indian Contract Act as well as the Transfer of Properties Act. So, consideration by law has to be legal tender. Legal tender means the currency. So, consideration cannot be like, against this property B will give me 50 calls a day, or tell me hi every day, or will do tasks uh, which are other than legal tender. It is not acceptable forms of consideration as far as a property is concerned. So consideration is a must, and it has to be a legal tender. Now, the reason why I had to talk a little bit about consideration is what happens in exchange. Okay, what what's going to happen when two parties are exchanging? Because you have a scenario where a property is exchanged for a property, right? So the consideration is not a legal tender, where B is not giving any money to A, but B is giving another property in exchange for this property. Okay. So these two properties are exchanged between two people through a single document, and that document is called exchange deed. Okay. So how does it work then? So in this case, the immovable property is considered as a consideration. So one of those two properties will be considered as a consideration or will be counted as consideration. But which one? Well, the property which is higher in value, let's say A is 1 crore in value and B is 1.2 crores in value. In this case, property B will be counted as consideration. And again, you have to understand that this value is not the market value we're talking about. It is a value, the true market value, which is a gentry value, which is higher. So whichever the property has the higher gentry value will be treated as consideration, and the gentry value of that property will decide how much stamp duty is to be paid for this particular exchange deed, right? And you would ask, what are the situations in which someone would exchange the property? Well, there are several cases in which you do not want to have two separate sale deed, uh, because both the parties mutually want to exchange a property, and in such a case, exchange is a single transaction, suffices the purpose where two properties are technically sold to either of the parties, two parties, they exchange. It is pretty popular among real estate developers. It can be popular within the family, father, son exchanging a property, uncle, niece exchanging a property. So it's very common. Exchange is common. It's commonly used whenever a situation arises where you may want to consider to exchange the property. Now, what happens if one of the property has a defective title? Now, usually it doesn't happen because both the parties are very much aware of the property that is being exchanged. But sometimes it can happen that one of the property is having a defective title. What can happen? Well, in that case, the worth of property exchange is not equivalent. That's one. The deviation of the prices is rewarded to the apt party. So one thing that the court of law can do is, if the two properties are not equal in value, at least the court can ask the other person to pay the balance amount or the amount which is higher, for which this exchange had happened. Secondly, what can happen is that they could seek for some damages in their loss, and they could claim the return of the property transferred. But you have to understand that if if possession is given, okay, once you have given possession within the exchange deed, it becomes difficult for the court of law to reward the property back to A. You know that this property is defective, so this property will go back to A from B. This would be difficult if possession is given. So if both the parties, let's say if A has taken possession and B has taken possession of this property, it is difficult for the court also to get this property back to A. So possession is very very important when you are looking at matters, legal matters of real estate. So once the equitable title is passed on, it is very difficult. A lot of that is with the possession. It is very difficult to reclaim that property. However, in exchange, usually we believe that both the parties have very good knowledge of the properties that is being exchanged, and so that is something that should not happen or does not happen in an exchange deal. Now, when you're looking at power of attorney, firstly, I would like to mention that power of attorney is not the kind of transfer, and that is as per the Transfer of Properties Act. Okay. What is it then? Well, one of the fundamental and important principles of modern management system, that's how I'm just defining this term, is delegation of authority. Be it could be an individual authority, sole proprietorship, partnership firm, private limited, public limited, any form of organization or person or entity can always delegate the powers of some to execute the work. And the legal terminology used for the documentation with regard to such delegation is called power of attorney. So let's say A owns this property if he has the legal equitable title, but he is out of country, or he is physically not present where the property is, and he gives the power of attorney to B. Okay. So when a buyer comes along, let's say C is interested in this property. C wants to buy this property. So in that case, in absence of B, let's say B is absent, B is not in this country. In absence of, sorry, A is not present, A is in some other country, and the power of attorney of this property is with B. So in that case, when C wants to buy this property, B is going to sign, okay, on behalf of A. Mind well, the document, the sale deed, will have the two parties' name as A and B. Okay, A and C. B is just a signing authority. B's name will not be there, but it will be mentioned that B is the power of attorney holder of A for this particular piece of property, and that power of attorney is another stamped document, okay, or a legal document, which is specifically talking about this particular property. Now, power of attorney can be of two types. One is a revocable power of attorney, and one is irrevocable power of attorney. In a revocable power of attorney, there is a time limit that this POA expires in months, or 2 months, or 5 months, or a year. Whereas irrevocable power of attorney does not have any time limit attached to it. Once the irrevocable power of attorney is given, A can never take it back. It is as good as sold. Okay. Even if A dies, this stays. But if it's a revocable power of attorney, there is a time limit. Okay. In that case, okay, if the principal dies, or if the principal is of unsound mind, who is the principal here? A is the principal. The person giving the power of attorney is known as the principal. Or if the business or agency comes to an end, okay, if the company is dissolved, or if the principal is adjust unsolvent, okay, in these cases, the power of attorney can be revoked. It will not be considered. Okay. Power of attorney can also be terminated by the operation of law when time expires. Okay, when the time limit is up, it is no longer valid, so it can become what we call void. Performance impossible. What if B dies? Okay, there is no way to perform it. Death, mental incapacity, and bankruptcy, and that we are referring to A. And if there is a partnership firm, but there are two partners which have, and if the firm dissolves, in that case also the power of attorney can become null and void. So I want you guys to have more questions on power of attorney, and have some questions on all the types of transfers that we have talked about. And we will have a separate session, a Zoom session, or I'll have a separate video on this, on your questions. So feel free to ask questions after you see these videos. And I would like to specifically apologize for bad audio quality because I'm trying this using this OBS Studio software to record the video, and I'm pretty new at recording online videos for tutorial purposes. So I think I'll have to buy a good mic, professional mic, to record these videos. But anyways, until the next class, what I want you to do is give me questions. Okay, uh, I'll delegate one person, take the question from all the students, and you can mail me the questions. And if possible, I'll make a separate video of the questions. And if the questions are straightforward, we'll just have a Zoom interactive or a WhatsApp chat interactive to answer the questions. So look up all the different types of uh, transfers: sale, lease, mortgage, gift, exchange, and look at power of attorney, and see, look at different cases when they have been used. Look at different legal court judgments where a power of attorney has created a problem in a property dispute. Look at these cases, and I'll try to come up with couple of case studies myself. So until next time we meet, just bring your questions in. Okay, thank you.